All persons having business before the Honorable Associate Judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Thank you. Good afternoon. We have one case on the calendar, In re ZM. The District of Columbia is the appellant. Before you proceed, counsel, I'd just like to remind you that given the nature of this case, a neglect case, you should take pains and be careful not to identify by name or otherwise the parties to the case. And with that, counsel for the government, Ms. Sonsini, you may proceed.
Thank you. Good afternoon. May it please the court, Pam Sonsini on behalf of appellant, the District of Columbia. I would like to reserve 3 minutes for rebuttal. CFSA's responsibility is to ensure the safety and welfare of abused and neglected children in the district. And to fulfill this obligation, CFSA must be able to act promptly to take children into custody before they suffer actual harm. This appeal poses the question of when CFSA can step in to protect a young child left without adequate supervision. The evidence established that 18-month-old ZM was a neglected child based on 2 statutory definitions of neglect. The court's order vacating these findings rests on several errors of law, each of which is independently sufficient to warrant reversal. The court misconstrued the plain language of DC Code section 1623(9)A subdivision 4 and misapplied the law related to subdivision 2. I would like to begin with subdivision 4 because it presents a rather straightforward definition of neglect, and the court's application is clearly contrary to the plain language of the statute. As all parties agreed, subdivision 4 presents a 2-part conjunctive standard. The first part, person or institution providing care states an intent to discontinue care, as the daycare clearly did here. The first time they called the police, and on the second time they surrendered the child and turned over the child over to them. The second time they surrendered the child directly to CFSA. The second part of the standard, the parent refuses or is unable to assume responsibility for the child. Here on October 21st, and again less than 2 weeks later, the daycare closed and the mother was nowhere to be found. She was refusing to care for ZM either explicitly or implicitly, and she was certainly unable to assume responsibility because she wasn't present.
And would you say the same is true if she showed up 5 minutes late to get her child from daycare?
Here the court found based on all of her conduct that those evenings that she was refusing or is unable.
I'm asking, I
understand.
If you could not fight the hypothetical for me for a second, I'm trying to understand. One way to read subprovision 4 is, there actually needs to be a substantial period of time where the parent has an opportunity to react. Otherwise, if a babysitter calls when you're out and says, you need to come get your kids, I have to leave right now, unexpectedly, suddenly you're a neglectful parent. Seems like an untenable reading of it to me. So I guess I'm curious what you think, what duration that somebody needs to be unreachable by phone before they're a neglectful parent.
If a parent is making efforts to make a plan, then they're not a neglectful parent. That isn't obviously the situation here. The mother being late or a babysitter becoming unavailable wasn't part of the parent's actions that the court used to make an inference that she was unavailable or unwilling. As the court found, even on review, it was a logical inference from the mother's behaviors that she was refusing or was unable to assume responsibility. And a delay or a caretaker suddenly unexpectedly becoming unavailable wasn't part of that factual background that was presented. Certainly, if a parent is running 15 minutes late and that's part of the information that is presented to the agency, the same inference would not be logical. It wouldn't be logical that a parent was neglectful because they were running late.
What if she got in a car accident and was 4 hours late?
Again, not a logical inference that she was unwilling.
I thought, so we're talking about refusing or unable, right? That's the statutory language that you're hinging your plain text argument on.
Correct.
And you're saying she
Refusing or
was
is
certainly unable because she didn't answer her phone. Same would be true if she got in a car accident and knocked herself unconscious for 4 hours, right?
Correct. And maybe for that moment, the child would be neglected. But when examining the totality of the circumstances in court, where here the trial court made a logical inference from the totality of the parent's actions that she was refusing or unable, in a situation where the parent, something unexpected happens, that would be a different situation.
But now you're just pivoting from the plain text argument that you began with to a totality of circumstances argument. Now I want to know what circumstances we take into account.
Here, in this case, what circumstances or
I
generally?
mean, just from looking at the text, I can't tell. Why is the woman who gets in a car accident not unable to care for their child when somebody who is MIA for reasons unknown, that person is unable, even though neither one of which have received the phone call saying you need to get here?
Well, I think in any event, when a child is left without adequate supervision, that child is neglected. What happens from that moment forward may be different given the reasons for that. But the plain language of the
Really? The
statute
car
does-
accident case? That's a pretty remarkable position.
Why is that remarkable? I would have thought that if a parent is in a car accident, has to go to the hospital, is unable to, or is unconscious or whatever, is unable to provide care for the child, then for the duration of that period, the child is in need of the intervention of CFSA and fits the definition of, assuming there's no other parent, and meets the definition of neglected. Now, the consequences of that and the duration of that might be other issues. One would say when the mother is out of the hospital or is able to make arrangements for the child, that the neglect has ended. And it would be absurd to think that a disposition of, and nobody would actually go forward with the adjudication if it happened fast enough. But it would certainly be absurd to say that a disposition in such a case would require removal of the child or probably any support. But in the meantime, there's a period where the child is neglected. Now, that's not true where the mother...
Does that summarize the district's view of what neglect means?
Yes, Your Honor. At that time, the child is neglected.
So the 5-minute example would do it too for the district.
Yeah, if the parent was late for 5 minutes, I mean,
Child was neglected for 5 minutes, right?
for those 5 minutes, the child was without adequate supervision. Correct.
Suppose the mother left a baby outside the house for 5 minutes on the street, unattended. You would say, I think, that the child is neglected for those 5 minutes. Now, that might not result in, any legal consequences for a variety of reasons. But I don't see why one would resist saying that the mother is, for example, not providing proper care for the child just because it's only for a short period of time. It could be a very significant short period of time.
And certainly the age of the child is relevant, as here or as in Judge Glickman's example, when you have a very young child who is unable to care for themselves or is at risk if they're left alone for any amount of time. In the two cases that this court has addressed subdivision 4, there's never been a temporal requirement. In both of those cases, the child went either directly from the caretaker who discontinued care to the police or from the caretaker discontinuing care directly to CFSA. There was no moment of time that the child had to be waiting for their parents.
In either of those cases, did the parent, just remind me, Was the parent unaware of the communication that the caretaker was discontinuing care?
Well, in WTL, yes, the parent was unaware and made that exact argument before this court, and the court rejected the argument that the caretaker had to alert the parent in advance. In that particular case, the caretaker turned directly to CFSA for assistance, and this court found that was all that was required under subdivision 4.
What was the legal consequence of the neglect finding in this case? And what would the legal consequence be if we were to overturn the associate judge's ruling? I understand there could be a stigma consequence for the mother, but what's the legal consequence?
The legal consequence of the dismissal was that the case was closed. The neglect petition was dismissed by the MJ after it was reversed on review, and the neglect case closed. Should this court reverse, the neglect adjudication would be reinstated. The court, if the agency deemed it was necessary, could hold another disposition hearing, but that's not necessarily what would happen. But yes, the neglect adjudication would be reinstated.
And it would be the basis for a disposition hearing. That in essence is the legal consequence, or it might be the basis for a disposition hearing.
That's correct.
Is that really a might?
It is really a might. The child has been home now for a little over a year, and many things could have changed in that time period. So it is certainly a might. The agency could assess the state of the child at the present time and determine whether further court intervention was necessary or not.
Is it also a might, had there been no reversal by the reviewing associate judge upon a finding of neglect based on these 2 occasions of the parent not coming on time to pick up the child, would there necessarily have been a disposition hearing, or is that also a might?
No, that's not a might. There would have been a disposition hearing. What the alternatives are at that point, the child could be placed into foster care, committed to the care of CFSA, or the child could be released to the parent under protective supervision. So there certainly would be a disposition hearing after a finding of neglect, but that doesn't necessarily mean that the child would continue to stay out of the home. In this case,
Ms. Sanchini, if I may ask you a question, just to be technically correct about this. My recollection is there was a disposition hearing immediately after the adjudication in this case. And the disposition was that the child was placed in foster care. So I think if you reinstated, I think the legal effect of the reinstatement, I'm thinking, would not be exactly a new disposition hearing, it would be a review hearing of some sort. Am I wrong about that? Or would it be technically called a new disposition hearing?
I think technically it would be a new disposition hearing to go back to the place where the AJ reversed the findings. That again, a lot has happened in the interim. And absent any information that would require the child to be removed, the child would remain at home. The court could reinstate the neglect adjudication, hold a disposition hearing, leave the child with the parent, and if appropriate, close the case at that time.
That raises the mootness question of why the district has an interest in pursuing this appeal as opposed to, say, opening a new neglect case tomorrow, which it could just as easily do.
Well, it could not open a new neglect case tomorrow absent new allegations of abuse or neglect. The district has an interest in the proper adjudication, not just of this case, but of every case that involves an unwilling caretaker, which is not an uncommon situation. Certainly children are not left at daycares all of the time, but children are left.
Sorry, just remind me, this was the daycare incident, that was 2019, right? We're 2 years past that?
We're exactly 2 years past it, that's correct.
Okay, and so I'm sorry, I should have said could open a new neglect case if they think anything has happened in the last 2 years that would constitute neglect. And if none of that has happened, what's the interest? in pursuing stale neglect accusations?
The interest of the district is in a proper reading of subdivision 4 primarily. If
I suppose I
the,
mean in this case, I mean, that sounds, I understand that to be sort of a capable of repetition yet evading review type argument. Is that what the district is hinging on?
we're not hinging on that, although we certainly think that exception applies if this case were moot. But there is an available remedy if should the district choose to exercise it. If the court were to find that the associate judge erred and reversed the court's findings, the neglect case that existed previously would reopen. So whether the agency chooses to exercise that remedy or not, we're certainly interested in a proper adjudication of neglect, not just of ZM, but of other children similarly situated.
I come back to the thought that if the case were, if we reversed and remanded and the case were reopened, the proper course would be for the court to call in the parties and say, okay, this case is still open. I need to find out what's happened in the interim and make a judgment about whether to close it or not. And that's why I called it a review earlier.
That's correct. The agency would be able to.
The judge to send the child back to foster care without doing that, obviously. But so it seems to me that's, and if the district found, and if in the course of that review, information came to light that suggested that the child's placement at home, was not in the child's best interest and or was in some way inappropriate, the fact that the case was still open, as it were, would enable the judge to take appropriate action, I should think.
And it would enable the agency to reach out to the family and
That too.
to assess how they're doing. And even if the child did not require removal, to assess whether the family is in need of services to make sure that the home is stable and the child, ZM's, is not at risk of removal. So if this court were to reverse, the agency could reach back out to the family, assess ZM's well-being, decide whether the child is safe at home and whether the family could benefit from additional interventions.
One of the questions.
After that, the district essentially has no business bothering the family unless it hears about new allegations. Is that right?
That's correct, Your Honor.
One other question, if I may. Do you think that this court has to, if it turns out that this court agrees with you on at least one of the bases for a finding of neglect, do you think it is necessary for this court to consider both bases?
I do not.
Do you think that one is narrower in some sense than the other?
Yes, I think subdivision 4 is a lot narrower. I think that the terms of subdivision 4 are very, they're very clear cut. They've been applied very, very literally by this court on prior occasions, whereas subdivision 2, that's where we open up the box of the entire mosaic and we assess whether the child has been receiving proper parental care and control in light of the history of neglect, the reasons for neglect. So I do think subdivision 2 is a much broader inquiry of neglect. Although in this case, I do think that ZM was a neglected child under both of them. But just one is necessary for an adjudication of neglect and for the neglect case to reopen if necessary.
Okay, well, let us hear from other counsel, and we'll give you a few minutes in rebuttal.
Thank you, Your Honor.
I'll ask counsel, how do you wish to proceed now?
Good afternoon, and may it please the court. I'm Catherine Pigatuk, FLE, on behalf of the minor child ZM, and the Mother's Council and I have agreed to share time. So I'll argue first for 12 minutes, and he will take the remaining 3 minutes.
Okay, thank you.
This court should affirm the associate judge's order for 3 reasons. First, the trial court did not consider the required mosaic and the evidence in the record was insufficient to show the type of mosaic that supports a neglect finding. Second, the record showed no evidence of any detrimental impact to ZM, nor substantial risk of serious harm. And third, the record does not support the required finding that ZM refused or was unable to care for ZM. I'll turn first to the insufficient mosaic to support a neglect finding under subsection 2. This court has explained in multiple cases what it means to consider the required mosaic. That is, in determining whether a child's welfare requires the intervention of the state, this court must go beyond simply examining the most recent episode and also look at, for example, any prior history of or reasons for neglect. Cases where this court has found a mosaic supporting a neglect finding show a pattern of neglect. For example, in Henry AS, a neglect finding was affirmed where unsanitary and unsafe living conditions that jeopardize the safety of children persisted over a period of several months. But it's also instructive to look at the cases where this court has reversed neglect findings. In Henry TG, this court reversed a neglect finding even where there were deplorable housing conditions, the children had rashes, there was little food, and the children appeared hungry. In this case, this court noted that those observations were made on a single day and emphasized that not enough focus was given to the physical and mental condition of children. In Henry AH, this court reversed a neglect finding after a parent administered excessive discipline to a 25-day-old infant who was also found to be clinically dehydrated, but there was no evidence that the child was not properly cared for prior to the incident. The facts of the current case, a mother's failure to pick her child up from daycare twice without any pattern of neglect or evidence as to the condition of the child, do not even rise to the level of concern of the facts in the cases where this court reversed neglect findings. The record shows no evidence that ZM had not been properly cared for outside of the 2 times his mother did not pick him up from daycare on time. No history or pattern of child neglect. And this goes to the risk of harm, which I'll turn to next. No actual harm and very low risk of harm to ZM.
Why do you say there was no risk of harm?
So this court has explained that it looks to both the, sorry, Your Honor, I lost my Zoom.
I meant, I hope my question was clear. I'm asking why you say there was no risk of harm in this particular case to the child.
There was no actual harm and there was very low risk of harm. So this court has explained that it looks to essentially 3 things: concrete evidence of harm, the risk of harm, that harm will befall ZM, and the severity of the potential harm. So looking at the risk of harm, the risk here really was that he would be left without supervision. Here he was not left unattended or without supervision at any time. And it's very unlikely that the daycare would have left him alone. It appears they followed protocol in calling CFSA, and he was safely transported to the agency where his mother came to pick him up. So the risk that harm would have befallen ZM is very low in this case, and there was no evidence of concrete harm. Turning next to the serious of the potential harm that could have befallen ZM, that is also low. While this court has cautioned against speculating, this court should consider how serious the harm could have been here.
ZM was 8 months old, is it?
Right?
That's
correct.
And should have been picked up at around 5:45, I gather, and was not picked up until 9 p.m. or sometime thereafter. Was the child fed by anyone during that period?
The record does not have any evidence of that. Did
the mother express any concern about whether the child had been fed in that period?
There's no evidence in the record as to that. So here,
just to clarify one thing, I think ZM is 20 months old at this point in time, right?
That's correct, Your Honor.
Okay,
18 months. I believe it was 18 months.
It might just be a big difference between.
Are we talking about the time? Are we talking about the time now or the time? When was the child born?
The child was born.
He was born in 2018, and in March. So you're correct. It was 18 months. Child was 18.
Correct. He was 8 months at the time of the removal. In any case,
I think Never mind.
Uh,
I think about a year and a half, actually.
Yeah,
Born
we'll
in
work
March
it out.
2018. This all happened in October, November 2019. So you've got a year and a half.
So in any case, I think the important facts to consider is that he was never left without adult supervision at any time. Here, it's true that CFSA had to step in to get him to the agency where he was properly supervised until his mother came to pick him up. Well,
Now, of course, so you think that that's a real defense to the mother, that she could rely on the fact that other people would step in her, absence?
I think it goes to looking at the entire mosaic, Your Honor. She was unable to be reached, and during that time, it's important for this court to consider that the child came to no harm and that the risk that he would have come to harm.
Well, it's fortunate.
So it is.
Well, I mean, I suppose your argument would be a little bit different if you left him in the middle of a street and some passerby came and cared for the kid. You wouldn't say that because that happened, the child wasn't placed at substantial risk. You would say that was happenstance. But here you would say the care provider did exactly what a licensed daycare provider is required by law to do, and one would expect it to do, which is either keep the kid until they get a hold of the mom or involve authorities, right? So
That's
I mean,
correct.
it's not just that you're not just relying on random happenstance. You're relying on an expectation that one can kind of bank on when you're dealing with providers like this.
That's correct. And that's why it's important for this court to look at the circumstances surrounding the allegations. Again, your honors brought up several hypotheticals. A child, for example, being left out in the cold without supervision, something like that is a far different scenario than we see here. And the facts here just don't rise to the level of neglect.
When you look at harm to the child, do you look just at physical harm? Do you look at psychological harm, for example?
Yes, Your Honor, you would also look to psychological harm.
It seems to me that the age of the child could make a big difference, or it could be a really important factor. I mean, it strikes me that one harm, at least to an older child, is the feeling of having been abandoned when everyone else has gone home and I'm here alone. Is that a factor here, or was this child too young?
That is absolutely a factor that this court should look at. And here there is just no evidence in the record that he had any emotional harm come to him. But again, this court has cautioned in Enrique KM against speculating about harm that could have come to a child. And while of course he could have faced some kind of emotional harm by not being picked up by his mother.
What do we mean by potential harm then? Don't we look to harm that could befall a child?
That's where this court has suggested that it looks to both the likelihood of risk of harm and the seriousness of harm. So there is, of course, some speculation involved in that, but we also have to look at the facts in the record. And what we have here is no information that he had any kind of emotional impact or detrimental psychological impact. All that we have on this record is his mother failing to pick him up on 2 times, him being safely transported to the agency, where again,
It's funny. Suppose the mother, this is picking up on hypotheticals the way Judge Deal was offering hypotheticals earlier. Suppose the mother had abandoned child to the agency. You would say, well, there's no harm because the child is being protected by the agency and by the police and by CFSA, who will step in. We wouldn't say the child wasn't neglected.
That question goes, Your Honor, to the question of time that Your Honors were inquiring about earlier. Of course, we would look to the amount of time that a child has been to determine that a child has been abandoned and what happened during that time. If a child had been abandoned for a significant period of time where the agency stepped in, that very well may be sufficient for a basis of neglect. But here the court does not have to make that determination because what we have is just a matter of hours before the mother came to CFSA to retrieve her child. And I think
You think it does not fit within category 4, type neglect?
Returning to category 4, no, Your Honor. The facts here do not establish that she was unable or unwilling to care for her child. On October 21st, when she learned that Ziam had not been picked up, she came to the agency that night to retrieve him. While it is true that there was a period of time, a matter of hours in this case, where she was unable to be reached, this court can look to its reasoning in INRE KJ, where this court's reasoning suggests that a parent is given some amount of leeway to make a plan for her child.
Well, sure, but here we have a situation where the judge did not believe her. So we have a situation where the mother does not come when she should for a few hours, pick up her child, leaves her child without contacting anyone, without contacting her mother to say, you better go for me, and offers no credible explanation for why she didn't do that. And then when she's cautioned, you shouldn't do this, as if she needs to be cautioned, 10 days later, she does it again. And again, she has no credible explanation. She just didn't do it. The judge can make a finding from that you were either unable or unwilling to pick up your child for that period of time. And it was not a de minimis period of time. I don't understand why that's not sufficient to find neglect. There's enough context there. We know the child we know who was on the list at the school to come pick up the child who was not. We know what kind of explanation the mother gave, and we know what the finder of fact thought of it. I don't quite see why that's not enough to find that, as the guardian ad litem apparently thought at trial, and I wonder if it's fair for me to ask you why the guardian ad litem at trial thought this was a case of neglect. I wonder why that's not sufficient to find that this child was neglected for that period of time. And it's a serious matter because the mother was leaving an infant, alone and not worrying about the care of that infant. And it's appropriate for the court to intervene. That's my difficulty with this case, if you want to call it that.
So the record here, while it's true that the judge did not find the mother, her testimony credible, there's really not anything else in the record that would counter where she was that night, why she didn't come to court. And so there's not a lot here.
Well, there's only one person who knows, and it's her. And she's elected not to tell the judge.
Well, the judge did find her testimony not credible, but I think going beyond that to ascertain from that she was unwilling to tell the judge, I don't think the record supports that.
Does she give it? I understand that the judge finds her incredible about asking friends to pick up the child, but I don't recall her offering any explanation beyond she had something to do. What was, or I think she had to go to her place of employment to hash something out about her hours on one instance. Am I remembering that right?
That's correct, Your Honor.
And then the other, did she offer any explanation of where she was?
The other, again, there's very little evidence as to what happened on the November 1st date, but both times she stated that she had arranged for somebody else to pick up ZM and that she wasn't able to be reached because her cell phone was not functioning.
And do you want to address or not Judge Glickman's question about the about face in the guardian ad litem's position in this case?
Yes, Your Honor. So GALs must act in the best interest of the child. That may and often does involve changing positions, given that circumstances for a child may and often do change over time. The GAL must constantly reevaluate given the day-to-day circumstances of children. At the time of the trial and the motion for review stage, the GAL supported a neglect finding in ZM's best interest, and we're in a different posture now, and so changing position. That's what the
But
GAL.
don't we have to decide whether the magistrate judge at the time erred or not?
That is correct, and the record here.
The fact that now it's not particularly in the child's best interest to be removed from the mother's care, which is what I hear you saying, is hardly a reason for us to say that the magistrate judge erred then, when even the guardian ad litem thought that a neglect adjudication was appropriate.
It's correct that ZM's best interests now do not have bearing on the record below. However, what this court starts to look at is the record below, and the record below does not have sufficient evidence to support a neglect finding. It is true that the jail changed position, but that doesn't impact the record below. And what this court should look to is the lack of sufficiency of evidence in the record below.
Well, I just wondered what it was in the record below that led the guardian ad litem at the time to agree that a neglect adjudication was appropriate.
At the time, the guardian ad litem argued that there was sufficient evidence in the record to support a neglect finding. Upon a further review of the record and also considering the changed circumstances, as appellee, I no longer take that position. Again, I would refer to the record, and the record stands on its own. There's just insufficient evidence in this record to support a neglect finding. Again, as your honors have pointed out, there has been a significant amount of time that has passed since the neglect case closed, and the government has taken no action to bring another petition or attempt to reopen this neglect case. And while that's not in the record below, it goes to explain the change in position, partially to explain.
So essentially, you're telling us that the guardian ad litem thinks that under current circumstances, it is not in the child's best interest for the neglect case to be reopened. But are you also telling us that you have reassessed the facts that initially led the magistrate judge to make her finding of neglect, and you now think those did not support the finding at that time?
It is correct that standing here today, I would argue that it is not in Zeem's best interest for the associate judge's order to be reversed, and also that the record supports that contention. So if there are not further questions, I'd like to close by noting the policy reasons to support affirmance of the associate judge's order. At the heart of this case is a mother's failure to pick her child up from daycare twice, resulting in no harm at all to her child. This court should not hold that is enough to support a neglect finding. Such a holding would leave the door open to a broad swath of families risking a neglect finding for being late to pick up their children, causing far greater harm to the integrity of the family relationship than the issues present here. Thank you.
Thank you. Mr. Nair?
May I please the court, good afternoon, judges. Your Honor, I represent the mother. Your Honor, I would respectfully ask this court to affirm the associate judge's decision. I will concur with the guardian ad litem's argument. Your Honor, as this court has repeatedly held that we have to look into the total mosaic of the case, not the isolated incident as to what happened. The evidence in this case has shown that other than the two occasions on October 26th and November 1st, the mother has repeatedly, picked the children on time. There is, this CFSS social worker has been to the home. There has been no other neglect other than these two isolated incidents. And as the guardian ad litem correctly pointed out, there is no psychological or physical harm for this child. The mother has given an explanation as to why she could not pick up child on those two occasions, and I think that evidence has been corroborated. My client's grandmother has actually corroborated her testimony, and the government has not put on any kind of rebuttal evidence to argue otherwise. So the finding, when you look at the totality of the situations, there is, other than the two incidents, that she has picked up the child on a regular basis. And if you take a position on
that's a tough line for you to take, where the regular basis did not extend so long. I believe the child was in daycare for what, 6 weeks by the time of the second incident?
That is true, Your Honor. Yes.
That's not a great track record.
But Your Honor, the testimony shows that the daycare worker herself testified that she has picked up. When you look at it, we are not talking about the several hours of her leaving the child. It's a few hours, and she gave an explanation, and that's a possible reasonable explanation as to why she could not pick up child on those two occasions. So if you take a position on it, any people in this country after time leave the children on daycare and other places, we are creating a very, 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 very bad precedent. Then we are always and neglect on so many occasions. People, sometimes parents will be late. So that is not the case. If the case has been in a situation wherein there on a regular basis, that is what's happening, that would have been a different case, but that is not the case. So under those circumstances, I would respectfully ask the court to affirm the lower court associate judge decision. And one other thing I would like to point out, the government is making an argument at 5 DCMR, but there is no allegation in the neglect petition that the mother has violated any of the 5 DCMR statutes. And the government did not make an argument in the trial court, and they did not even make an argument at the associated judge that there is a violation of DCMR statute. So I would respectfully ask the court to preclude the government from making this argument for the first time. That's all I have at this time.
Wait, what argument did they not make to the associate judge?
You know, in their brief, the government make an argument that this is a violation of 5 DCMR statute. That would be talk about the daycare center are governed by the 5 DCMR statute, and there is so for the facts and circumstances of the case that statute does not apply for the facts and circumstances of the case. The government did not make an argument in the neglect petition. The government did not make an argument or did not allege that my mother has violated the 5 DCMR statute.
Well, are you disputing that the child care center was the daycare center was the kind of institution referred to in the 4th category of neglect?
I'm respectfully, I'm not disputing that. But the fact when you look at
so that's really the end of that question, isn't it?
Well, again, the parties, the government had an opposite. They have to at least make an allegation. They have not made an allegation. They failed to make an argument for the associate judge, and for the first time, that's why that statute the government would preclude it from making that argument at this time. That's all I have at this time. Yeah.
I'd like to hear your articulation of what the mother's explanation was. We've been talking about it. I think we've all read the briefs. We know, but you made the point a couple of times that the mother explained why she was late picking up the child. Tell me what her explanation was, as you understand it.
Respectfully, Your Honor, that the explanation was that on 2 occasions, on one occasion, he has asked another boy, I think her boyfriend, to pick up the child. But that has been corroborated by the grandmother. But apparently, that gentleman did not pick up the child, and she didn't know until she came back because she didn't get the telephone. The grandmother testified that her phone was off, she was not working. So she explained as the reason why she could not share another person.
What did she say about the name of this individual?
I think, Your Honor, she mentioned a name called Dada. She could not give the full that's all the name we have. This on the second occasions on November 1st, I believe she had made arrangement for another girl to pick her up, but that girl has her own problem. She could not pick up her own child on occasions. So that was the explanation. It is not something intentional. When you look at if somebody has did some intentionally try to not pick up, that is not the case here. She had made arrangement. That is before the court. That is her.
Do you see any problems? Assume for a moment that she was telling the truth, that the mother was telling the truth, and that she had indeed. I put it that way because the judge did not credit her. But assume she did those things. She made that request of, I don't know how to pronounce the man's name, Dada or Dada. And she made the request of some girl who she did not identify. Do you think those were good plans? Do you see any flaws with those plans?
You know, respectfully, I don't see any problem with those plans. People.
You think it would have been okay for the child care center to give this 18-month-old child to those people when they showed up?
Your Honor, that there is no evidence to the contrary that the child care would not have released the child the evidence in the case has shown that there are at least some portion of the testimony that other people has picked up the child. I think at least 1 or 2 occasions that the other man has picked up the child from the daycare. So I assume that I have answered Your Honor's question.
I'm sorry, I did not hear the last thing you said.
I think Your Honor, in the evidence case, there was at least on 1 occasion, there was another gentleman who has picked up the child from the daycare. So just to answer Your Honor's question, yes, the daycare has no reason to not to place it, not to give the child to the whoever the mother has.
I asked that question because I thought the evidence was that the daycare needed to have confirmation in terms of a list, the person being on the list of the people who could pick up the child. I mean, I must say, if I had a child at a daycare center and I heard that anybody could come off the street unknown to the daycare center and say, I'm here to pick up that child, and the daycare center would just give the child to them, that strikes me as grounds for taking away the license of the daycare center.
But respectfully, that is not the case here. That is not the case here. The fact of the evidence in the case has shown mother has made a suitable person to pick up the child on those 2 occasions. Apparently, for unknown reasons, that did not happen. But again, that alone would not constitute what we will call as a neglect. That's all the argument I have.
Okay, thank you. Let us hear from Ms. Sanchini for the government. We'll give you a few minutes in rebuttal.
Thank you, Your Honor. I would first like to discuss the GAL's arguments regarding the harm to the child. As this court held, there is no requirement that harm come to a child before the agency is permitted to step in to protect that child. Here, a child left unattended, certainly for even a small amount of time, is at risk of harm.
Do you disagree with her legal tests that it would need to be a substantial risk of harm under the circumstances?
No, Your Honor. In many cases, either addressed by this court or seen by the court below, when subdivision 4 is alleged, the child is turned over from one institution to another, whether it's a hospital or juvenile detention or another caretaker. The child is turned over from one caretaker to another. There's no requirement that harm come to a child or that some serious risk of harm is possible during those moments.
I guess I was more curious under prong 2.
Under prong 2, I think a child of that young age left unattended, transported by the police on multiple occasions, there is a risk of harm. Certainly.
Do you agree with the legal test that it needs to be a substantial risk of harm?
I think it needs to be a likely risk of harm, yes. Okay. And a child that young certainly is more likely to suffer harm if left with an inadequate caretaker. There's been a lot of discussion about mom's explanation for her failure to show up. Ultimately, the court didn't credit any of her testimony from trial. The court did not believe that the mother had a plan. When she first presented to the agency late in the night, shortly before 10 p.m., she claimed that this gentleman had been asked, but she didn't have a first name, she didn't have a last name, she didn't have a phone number, she couldn't show a text exchange. So the idea that she had a plan that fell through is not supported by any of the facts here. And as Judge Glickman noted, the daycare director testified that in order to release a child, they would have to have his name or her name, and they would ask for identification when this individual showed up. So in any event, whether she'd asked a girl from school to pick up her child, it wasn't an appropriate plan for the care of the child.
Have you ever applied 9A4 to somebody who was less than a full-time caretaker, like a babysitter or a daycare?
Has the court ever applied in a published opinion? No. but the agency certainly sees many of these cases come through its doors. In fact, of children aged 15 and over in fiscal year 20, 79% of the kids in care at this time came in due to an unwilling caretaker. So this isn't an unusual situation. It does occur, unfortunately, with some regularity.
What percentage of those were for a matter of a few hours?
I don't have a temporal.
I'm not sure it's so
limit, but-
helpful without that.
But Subdivision 4 doesn't require any amount of time. In the cases that have been published, the children have been turned over directly. They haven't
From a
spent
permanent
any
caretaker, right?
from a caretaker. Well, from an individual. In WTM, or excuse me, in INRE KJ, the child bounced around from relative to relative to relative until eventually they called the police and the child was picked up because none of these individuals were willing to continue providing care. And in none of those cases did they wait for harm to fall or decide that the child had to be left alone or unattended for some period of time. The last thing I just want to add is regarding the entire mosaic. I think it was an error for the reviewing court to find that it was not considered. Certainly the court's findings of fact review a lot of other testimony other than these two incidents, not one day of failing to pick up, but two incidents, as well as information from the social worker that the mother showed up close to 10 p.m. and was under the influence, and testimony from a doctor that said that she had concerns about the child's low birth weight, the concerns about food insecurity, concerns about discontinuing.
That reminds me of something I wanted to ask you. It's problematic for you in one sense to rely on the pediatrician's testimony because it does not appear as if the trial judge was willing to consider it for more than a very limited purpose. But my understanding, correct me if I'm wrong, is that the mother's counsel objected to the introduction of the pediatrician's testimony. And it was his objections that probably did, or I think, but may have caused the judge not to consider it. And the reason I bring that up is because it leads me to think that it's a funny position the mother's in here. She objected, in effect, to the judge considering the entire mosaic beyond the two incidents here. She objected to consideration of evidence that would provide additional context of her care of the child, and yet now is arguing that the failure of the judge to consider mosaic evidence is a flaw in the judge's decision-making. And I guess the question I would ask you is, does my characterization that I've just given of this, is that correct, or am I misunderstanding the record here?
That's correct. And it certainly rings of invited error to object to all of this information and then fault the court for not considering it. But the court did, despite the objections, did hear information, limiting it only in the context of how the doctor's testimony went to whether the mother was providing proper parental care and control, which of course includes medical care. There was the conversations about whether there was medical neglect alleged or not, but ultimately I think that the court did receive information from the pediatrician who testified regarding her concerns about the child's weight gain. The child had been born very small with a potential life-threatening condition that required medication that the mother had discontinued without medical advice. So all of these facts do provide a background in addition to the mother's own admissions that she uses drugs. So the government would ask the court to reverse the lower court's findings, dismissing the neglect petition pursuant to subdivision 2 and subdivision 4. Thank you.
Council, thank you all. Case is now submitted, and you all may log off.
This honorable court is now adjourned.
Thank you.